6.4, consideration of presentation of Brown Act, and this is County Council's item.
Yes, thank you, Mr. Chair. Good morning, members of the board. We do have a PowerPoint presentation of sorts on this. And I'll just prompt staff to move on to the next slide. And so just as by way of background, my name is Lloyd Gintivano, County Council, and the purpose of this presentation is to just give you a high-level outline of sorts, highlighting some of the more pertinent aspects of the Brown Act for your board and also for the public. The PowerPoint presentation, of course, has been uploaded in the county's Granicus website, I believe, and so it is publicly available for reference, not just for your board, for your board's reference, but also county committees, councils within the county of Lake. So, what is the Brown Act? Well, it's authored by it's named after Ralph Milton Brown, Central Valley Assemblyman, and this was passed in 1953 to safeguard the public's right to access and participate in government meetings within the state. The actual code sections are located in the government code, sections 54950 to 54963. And for purposes of this PowerPoint presentation, I just plan to highlight a few things so that we can move things along. But of course, if any members of your board have any questions, feel free to just raise your hand or flag me. So next slide, please. So the intent of the Brown Act, just to highlight a few of those things, is so that the public, members of the public have insisted on remaining informed so that they may retain control over the instruments they have created. And the whole default purpose of this for the Brown Act is to keep, as much as possible, all meetings to be open and public, and all persons shall be permitted to attend any meeting of the legislative body of a local agency. And then there are some exceptions to that, of course, which I will also get into. Next slide, please. Following through with this intent, it's really the whole concept behind this default sort of intent or purpose of the Brown Act is to ensure that the businesses of the local government are conducted on behalf of the public, and that is certainly most certainly the public's business. And that's the transparency part of it. Next slide, please. So we get into who is subject to the Brown Act. The Brown Act uses the term legislative body, and that's a term with a specific definition. It includes all governing board of local government agencies, advisory and standing subcommittees created by such governing boards, and all boards, committees, and bodies created by federal or state law. Next slide, please. So then we get into the Brown Act also uses the term meeting or meetings. So it's a very specifically defined term, and a meeting is a majority of the members of a legislative body present at the same time and place to hear, discuss, or deliberate government business. It's also defined as a congregation of a majority of the members, which involves any aspect of that decision-making process that triggers Brown Act requirements. So some of the key terms there for under that definition is a majority of the members. So it would consist of at least a majority of the members. In your board's case, that would be at least 3 out of the 5. There are exceptions to within that definition of what counts as a meeting, and that's what we have there. Some of the exceptions are kind of conferences, trainings, seminars, community forums, and meetings of other government bodies, and social occasions. What I will say, though, under the set of exceptions is a lot of it will hinge in terms of determining what's a meeting or not. A lot of it hinges on the substance of what's being discussed by at least 3 of the board members, right? Again, under that majority definition. So that even if, say, 3 of members of a legislative body, the majority of that legislative body, is attending a social occasion, which would not normally constitute as a meeting. However, if what's being discussed in that social occasion between these 3 members consists of matters that's within the board's purview or within the board's jurisdiction that would normally be discussed in an open meeting, regular meeting subject to the Brown Act, then that is a meeting. even if it's within within an event such as a social occasion type of event. Right. So next slide, please. So in terms of what to avoid, this gets into the electronic forms of media. Again, it references majority of the members may not use telephone, email, fax, internet-based social media platform, or other electronic means or devices, or an intermediary, that's a third person, to discuss, develop a consensus, agreement, or decision. Because again, the intent behind that is to have that be discussed in a regular meeting for the public to see and for public participation. And then next slide, please. And so there are two types of meetings, generally speaking, based on how it's defined in the Brown Act. I see that on the third bullet point there. There's a hub and spokes communication where the letters there represent members of the legislative body, where member A discusses a certain topic within the body's purview to member B. A also discusses it to member C, and then A to D. And now you have at least three members of the legislative body under that hub and spokes communication that would normally count as a meeting, even if it was discussed by means of email, electronic devices, or just verbally. It would still count as a meeting that would then trigger these Brown Act requirements. The other type of meeting is called a chain or daisy chain communications, where member A would discuss a certain topic with member B, and then member B in turn would discuss that same topic to member C, and so on and so forth until you get at least three members who are participating, three or more, and that would also count as a meeting that would also trigger Brown Act noticing public participation requirements. Next slide, please. Also, in terms of what to avoid, polling of the members of a legislative body by another member of that body, either personally or through staff, is prohibited under the Brown Act. However, staff, not the members of the body, but staff can meet individually with the majority of the members if staff does not provide information regarding any other member's views. So that responsibility would fall on to staff to make sure that the hub and spokes is not triggered or does not trigger the Brown Act requirements. Next slide, please. So we get into noticing requirements. There's generally three types of meetings, and it's laid out there in the Brown Act, of course, for a regular meeting, much of which applies to regularly to how we post agendas here for our board meetings. 72 hours advance notice is required. For a special meeting, it's 24 hours advance notice, and they get into specifics as to how it's noticed, where it must be posted. But those are the timelines. And then for an emergency meeting, notice must be posted 1 hour in advance, and news media, and certain notices have to go out to news media organizations and other individuals or parties who have requested the advance notice. These emergency meetings typically would apply to natural disaster type of situations where a meeting has to occur right away. Action needs to be taken right as soon as possible, and that's why you have the just 1 hour in advance notice would suffice under an emergency meeting category. Next slide, please. Then we get into just agendizing requirements. The agenda generally would only require, what's only required is that the agenda provide a brief description of every item to be discussed, including closed session, and that gets into specifics as to the type of language to be used in a closed session caption. But the descriptions must be clear enough to be understood by members of the public. Next slide, please. And so the function of the agenda, which is the paper document that's being posted out there and also electronically on the county's website, is a promise made to the public by the legislative body that these are the items that would be discussed in the upcoming meeting. Generally speaking, it's provided in 20 words or less, but again, it must be sufficient to allow the public to determine whether they wish to participate. That's the standard of how much information should be placed in an agenda caption or description item for the agenda item. Next slide, please. And so there are subject to certain exceptions, no action or discussion shall be taken on any item not appearing on the agenda. And here are the exceptions. Members of the legislative body may respond to public input, and we just had that early as part of our regular list of set items. Make reports of activities or announcements. You see that here in our regular meetings, such as our calendar items, right? And your board may also ask staff to report back on a matter at a subsequent meeting, or provide direction to staff to place a matter of business on a future agenda. Next slide, please. And I think this one generally refers to extra items, I believe. Additionally, the legislative body may take action on an item not appearing on the posted agenda if there is an emergency or there is a need to take an immediate action which came to the attention of the legislative body after the regular meeting agenda has been posted. So that has been utilized by your board before. Typically, agenda items are posted on or about Friday before the Tuesday regular meeting, as an example. And if something comes, an issue has, if there is an issue that comes up after it was posted, then that would be an option for staff and the board to utilize. As an extra item, bring it up at the Tuesday meeting, goes through the motion requirements in order for your board to take it up, despite the fact that it's not posted. It was not included when that item was not included when the agenda was posted. So next slide, please. So location of the meetings. Public meetings must be held within the boundaries and the jurisdiction of the government entity. There are a list of exceptions to that, such as the inspections of real and personal property, meetings with federal and state officials, and holding closed session with legal counsel. And the next slide, please. So this one covers the public input and public commenting sections that takes place, that occurs during a meeting. So the members of the public has the right to address the legislative body on both agenda items, which would be public comment, and non-agenda items, such as the one that took place just a few minutes ago, and public input. Those terms are used interchangeably, but essentially one is for the public to make comments on items that are posted in the agenda, and then the other is what usually occurs at the beginning of the meeting, sometime at the beginning of the meeting, where for items that are not posted in the agenda, the public can also comment on those items that are not posted on the agenda. So next slide, please. And I think this one just goes to, again, the general rights of the public, unless subject to a closed session exception to the legislative body, meetings of the legislative body must be open in public, has to have accommodation for disabled persons to ensure access and participation. As far as copies of the agenda packet items, members of the public have the right to obtain copies of all written materials which are distributed to the board, with the exception of privileged materials. And also, members of the public can audio and video record and take photos of the proceedings or broadcast them, unless doing so creates a disturbance. Next section, please. And then next category is closed session. Much like open session items, the closed session item must contain a brief description of the item, and it's laid out specifically. The statutes themselves, the government code sections, lay out suggested language or recommended language of what to put in the closed session description item. Each such item requires a pre-closed session announcement, which is what your board typically does before getting into closed session. Except for those reporting out requirements, strict confidentiality of closed sessions must be preserved. And again, that's outlined in the statute as far as any action to be taken coming out of closed session. It only applies to certain closed session categories. Next slide, please. Thanks. some of these, there's a whole list of closed session items, and I'll just highlight a few of them that may apply to your board. Personnel matters would be a closed session item, and the appointment, evaluation, discipline, or dismissal of an employee. Labor negotiations are part of are a closed session item, which consists of meeting with local agencies, bargaining representatives to discuss negotiation matters. Next slide, please. Other categories are pending litigation, to meet and confer with me, or legal counsel in my office. Real property negotiations are also a closed session category item. Next slide, please. And then there's also security of public facilities and services. Again, the general intent here is to carve out certain exceptions that would not normally be made open for public participation based on certain policy concerns, such as this category here, which is security of public facilities and services, where involving matters where there's a threat to the security of a public building. Next slide, please. So with all of those requirements of the Brown Act, what are the violations? What's the consequences of that? Well, violations of the Brown Act can lead to an invalidation of an agency's action. So if an action was taken by a legislative body, that same item may need to be taken up again if there is a determination that there was a Brown Act violation in the course of that leads up to that determination or action by the legislative body. Other consequences include payment of a challenger's attorney's fee, civil liability, and criminal liability based on a misdemeanor. Now we get into the teleconferencing requirements under the Brown Act, which I know there's a few legislative bills that are in the pipeline. They haven't been adopted yet. So as it stands right now, and my office, of course, will provide updates to those as soon as they come in. But as it stands right now, the teleconferencing under the Brown Act consists of two main types of teleconferencing. Teleconferencing essentially refers to remote appearance, anything other than being in person during an irregular or special or emergency meeting. So the first category is traditional teleconferencing, where generally speaking, agendas must be posted at all teleconference locations. So in a situation where a member of a legislative body wants to appear remotely, the agendas must be posted at that remote location, and each teleconference location must be identified and noticed at agenda and must be made accessible to the public as well. So that's under traditional teleconferencing. Until January 1, 2024, this is under AB 361, legislative body can use teleconferencing without complying with the Brown Act's teleconferencing quorum, meeting notice, and agenda requirements set forth in government code in very specific circumstances. Next slide, please. And these are the specific circumstances. There you have one of which is a proclaimed state of emergency. If there's an imminent risk to the health and safety of attendees, those are pretty narrow items to that this teleconferencing option under AB 3621 would apply to, and so it doesn't really come up that often. The next category is a little more flexible, which is under AB 2449. This also exempts the need for certain in-person quorum requirements, but it is also subject to certain conditions. At least a quorum of the members of the body must participate in person. So there must be at least 3 members of a 5-member legislative body that needs to participate in person if any one of the other members wants to participate remotely. Next slide, please. These go into the specific types of audio-visual requirements. There has to be a two-way audio-visual platform or a two-way telephonic service to allow the public to comment when at least one of the body members is appearing remotely. There has to be notice, the means of the public to access the meeting and offer public comment through that two-way audio-visual platform. Next slide, please. The legislative body must identify, include an opportunity for all persons to attend and address the legislative body via this call-in option or call-in feature. And it has to offer the public to comment in real time. Again, this is all within the umbrella of AB 2449 in a situation where at least one board member would want to appear remotely. Those are the specific requirements. Now we get into the basis for or the grounds that would allow for this type of remote appearance by a legislative body member. The standard is just cause. So the board member who's appearing remotely has to provide a general description of the circumstances relating to their need to appear remotely at the given meeting. The provisions cannot be used by any member for more than 2 meetings per calendar year, or, next slide please, or the member requests the legislative body to allow them to participate in the meeting remotely due to emergency circumstances. So we have a just cause category or emergency circumstances in which remote appearance under 2449 would apply. Next slide, please. And then the board, the other members who are appearing in person may decide to allow the member to participate remotely at the earliest opportunity. So there must be action taken by the remaining members who are not appearing remotely to allow the remote member to participate. And then there are these additional requirements on how often can a board member utilize this. Only for a period of more than 3 consecutive months or 20% of the regular meetings for the local agency within a calendar year, or more than 2 meetings if the legislative body meets fewer than 10 times per calendar year. That doesn't apply to your board, that last clause. So now, next slide. Yeah, there you go. Just cause. Under that, what does that consist of? Well, it's child care caregiving that requires them to participate remotely. There's a contagious illness category, physical or mental disability, not otherwise accommodated, or travel while on official business of the legislative body or another state or local agency. And next slide, please. I also covered the emergency circumstances, which is generally defined as a physical or family medical emergency that prevents a member from attending in person. I will say that when it comes to the process of providing an explanation or justification by that remote member on why he or she would be appearing remotely, when it comes to whether it's under just cause or emergency circumstances, the suggestion here would not to provide medical information because that is subject to HIPAA. So because that explanation itself would be provided in the open meeting in which that member is appearing remotely. So the suggestion there is to provide just a general description of those circumstances that would fit any of those categories, but not necessarily HIPAA related information or not medical information, not specific medical information. So, oh yes.
Is this the one that's coming up for renew, or they're looking to extend it to 2030?
You know, I'll double check on that. That's the one, what I've laid out is the one that's currently in place.
Yes.
Whether or not, the ones where they're looking to extend it or modify it to a certain extent, that's still in the pipeline through the legislative process.
Right, and yeah, we had just signed to
Yeah.
approve it, to recommend it.
Oh, yeah, but as soon.
I'm asking if that's the one.
Yeah, this is the one that's currently
Okay.
in effect, right? And if there are any modifications or updates, is this coming down from, say, the legislature? If it's adopted, my office will certainly provide that up to your board by way of a presentation.
Thank you.
So the last category is Senate Bill 1100, which deals with the disruption of a board meeting and what your board can do. Presiding member of the legislative body conducting a meeting may remove or cause the removal of an individual for disrupting the meeting. There has to be a warning first, though, to that individual that their behavior is disrupting the meeting, and if the individual persists, then that action, the removal action, may be utilized. Next slide, please. So, what is disruption? It's defined as engaging in behavior during a meeting that actually disrupts, disturbs, impedes, or renders infeasible the orderly conduct of a meeting. It includes failure to comply with reasonable and lawful regulations adopted by the legislative bodies, such as, your board has their own regulations under Chapter 1, policies and procedures of the county as to how meetings are conducted. And also, disruptive behavior also includes behavior that it constitutes use of force or a true threat of force. And I think that's it, unless your board has any questions. That is the end of the presentation.
Supervisor Sabatier?
Thank you for that. I just wanted to, two things. One, we were just talking about the latest meeting rules for teleconferencing. I believe that the sunset clause is January 1st of 2026, so that is upcoming. If there's nothing new, those just go away. If there's no extension, no nothing. Looks like I'm getting a yes, so that's correct. Number two, you mentioned something that I think is, I'm going to slightly disagree with, that it's on staff to know that, but not necessarily, because the liability is on us for Brown Act violations, right? You can't go after a staff member for violating the Brown Act. That is our purview to ensure. So I hope that maybe during a department head meeting, because there's certain department heads that I've had to stop from telling me what other supervisors have told them, that I hope that you can provide such an educational presentation to make sure that everybody, whether they're new or not, it's nice to get a review. It's nice for us to get a review, even though we know what the Brown Act is, just because we fall into traps sometimes of wanting to say more than we should, but the liability is entirely on us to prohibit people from saying certain things when we know that they're starting to tell us how others are feeling about certain things that we're eventually going to vote on. So I just wanted to change that that's not on staff, that's on us, but I think education all around, not just the board, should probably occur.
I had a question. I know that we covered a lot of mainly what has to do with meetings, but there's also some rules, and you'll stop me because it's getting into a couple things, whereas the public commonly thinks that, for example, one of us has the oversight over a director and that we can tell that director to do X, Y, and Z, and that's a directive. I don't know if this falls in that purview, if it falls in a different one. Maybe you can help me with that.
So that is allowed because under those circumstances, you have one member speaking to one member of staff, right, or a group of staff over a topic that's normally within the purview of the board. That does not constitute a majority of the board members on its face.
Right.
But certainly, and it relates to Supervisor Sabatier's point, if there is information either coming from staff or the board that lends one to view it as it's not just one board member anymore over the same topic that's discussing the same topic, it's getting close to, say, a majority of that, then there may need to be a pause there, because normally that would be something that would be agendized, noticed, and then it's set up for board discussion over an item.
I think you might be talking about the policy.
Yeah, and I think that's something we'll be talking about later. But yeah, I'm just getting, we'll talk about that later. What I'm getting at is one supervisor or two supervisors does not have the ability or cannot tell a director or give them direction or orders or anything like that. But that would be in a later item I think we're talking about.
Correct,
Yes.
correct.
Okay.
That is, yeah.
All right, we'll talk about that another time. I'm just trying to, see if it fits in here at all, so. Did you want to, anybody else?
Supervisor Pyska said exactly what I was going to say.
All right. All right. Are there any questions from the public? Anybody online? Yep. Come on up, sir.
Good morning, Board. My name is Tom Lasik. If I may indulge them to maybe go back to the presentation and the first few slides on standing meeting. This is a unique situation that came up in the Board of Supervisors meeting on March 25th. And a member of the public, Betsy Kahn, made a comment about it. I believe it was I'm going to have to look it up here, I apologize. It was a drought water shortage task force. I don't know if you recall that, it was March 25th. And it was decided to create a standing ad hoc committee. A standing committee requires Brown Act, and an ad hoc committee does not. And it was noted as a contradiction. And you can see your standing subcommittees. So I would ask that, I know you can't respond, but I would ask that you take a look at that again, because an ad hoc committee is only supposed to be members of the legislative body and is not subject to the Brown Act. But a standing committee is. And so it's unclear to the public where we actually land on that particular example. So that's what I'd just like to point out, that I want to thank council for putting the presentation together. I've seen it before in other contexts. It's really good. But this is an example of where I think the Brown Act, where the rubber hits the road. And we just want to make sure we're doing it the right way. Thank you.
Thanks. I don't know if you wanted to add anything to that, or?
For that, just generally speaking, we could, staff my office will certainly look into that issue. I've got the name of the committee, so.
Okay, thank you. Any other public comment? I realize I've interchanged the two every now and again. I'll say public input, but that's at the beginning of the meeting, public comment. All right, none on Zoom. If there's none on Zoom, we'll go ahead and close this item